See the money won't stay for your meal, getting all a piece of pie for your wife. Everybody wanna know how it feels.
Gentlemen, we are going to examine Novation of Contracts. Section 62 of the Contract Act says if the parties to contract agree to substitute a new contract for it, or to rescind or alter it, the original contract need not be performed. The original contract need not be performed. The careful examination of this section shows that this section has three parts. One is the contract, the second is the novation, rescission and alteration, and the third one is the effect of novation. This section may be studied in these lines. Contract, what is? A contract is an agreement enforceable by law, meaning thereby an agreement enforceable by law is a contract. Then it is an agreement. So what is an agreement? Agreement, what is? It has been defined in the Contract Act. Every promise and every set of promises forming the consideration is an agreement. Every promise and every set of promises forming the consideration is an agreement. So the agreement may be void. A void agreement need not be performed, and there are voidable agreements as well. Those are known as voidable contracts. Those are enforceable by law at the option of one of the parties or some of the parties, and the others have no option to exercise the same. So one party has the option to either to rescind the contract or to accept the contract, and in that agreement is enforceable at the option of the party. That is available. The contract which is enforceable is really a valid contract. How this question can be resolved, and specifically the performance of the agreement should be performed. Section 12 of specific defects says, except as otherwise provided. In this chapter, the specific performance of any contract may, in the discretion of the court, be enforced. A. When the act agrees to be done is in the performance wholly or partly of a trust. B. When there exists no standard for ascertaining the actual damage caused by non-performance of the act agreed to be done. C. When the act agreed to be done is such that pecuniary compensation for its non-performance would not afford adequate relief. D. When it is probable that pecuniary compensation cannot be got for the non-performance of the said act agreed to be done. So these are the situations wherein an agreement may be performed. So this type of agreements can be specifically performed as given in section 12 of the Special Relief Act. So for the purpose of novation, there should be an agreement enforceable at law. If the agreement is not enforceable law, it is not a contract stricto sensu. But when it is not a contract, novation of contract does not arise. The novation of contract takes place only when there is a contract which can be specifically performed. And the contract which cannot be specifically performed, the novation of that contract cannot take place. So for the purpose of novation, it is necessary that the agreement should be enforceable. If we find that there was an agreement which was void agreement, there can be no novation of that agreement. There can be no substitution of that agreement. There can be no alteration of that agreement. That agreement may or may not be rescinded, carries no weight. So for the purpose of novation of contract, there should be a valid agreement enforceable by law. When a contract is enforceable by law, it may be substituted. Now the second part is what the novation is. Novation obviously is substitution. It has been defined by very authoritative pronouncements of our courts. PLD 1969, Baghdadul Jadid, page 70. Contract Act section 61 and 62, novation. The meaning of novation of contract is thus explained by the House of Lords in Benjamin versus Alford case, that the what is novation? That there being a contract, its existence, some new contract is substituted for it, either between the same parties or between different parties, the consideration mutually being that the discharge of the old one. So far as the novation is concerned, it is a theory which is based upon the desire of the parties. The novation of a contract hinges on the desire of parties to rescind the contract, to alter the contract, to modify the contract, to substitute the contract. So the desire of the parties is the basic ingredient, meaning thereby that there can be no substitution without agreement of the parties. If both the parties agree and both the parties desire, then there can be substitution. In PLD 2019, Lahore 333, novation for proving of novation of contract. It gives us the essential ingredients of the novation. Novation, what is and what are the essential ingredients of the novation. These have been enumerated in PLD 2019 Lahore page 333. Proof of novation of contract. Essential ingredients. Scope. Novation of contract was where new contract was substituted for a contract in existence, either between the same parties or between different parties, and the consideration mutually being the discharge of the old contract. When agreement was substituted, both such agreements were supposed to be read together to form a complex substituting agreement. For proving of novation of contract, it must be shown that firstly there was existence of a previous valid agreement. If there is no previous valid agreement, there can be no substitution and there can be no novation. Secondly, there was an agreement of the parties to cancel the first agreement. So mutuality of the parties is important, that both the parties should mutually agree to rescind the previous one, to alter the previous one, to substitute the previous one. There was an agreement of the parties to cancel the first agreement. Thirdly, that there was agreement of the parties that the second agreement replaced the first one. Only rescission of the first one is not novation. For the purpose of novation, there should exist a new agreement, a new contract to replace it. If the parties agree to cancel the agreement, then it is not novation. Novation takes place only when the document is executed in accordance with the new agreement. So when there is a new contract, in substitution of the previous one, that is novation. And fourthly, to prove validity of the second agreement. It is very important. It means that the agreement which is being replaced should be a valid one, and it should be substituted by a valid one. So both the contracts should be valid. If the previous contract is valid and the substituted one is not valid, then it is not novation, because a valid contract is necessary for its performance. If there is no valid contract, it cannot be specifically enforced. So the condition, fourth condition, which is shown in this authority, is that there should be a valid second agreement. Second valid agreement is necessary for the purpose of novation. There is another authority. (2016) CLC page 351. It gives the meanings of novation. Novation means and be construed when contract already in existence is extinguished and a new contract is created whereunder new rights emerge in favor of parties. Unless rights under the old contract are explicitly relinquished, no new contract comes into force. This is very important, that the rights existing in the previous contract, in the old contract, must be extinguished, and the rights in the new contract should be created. If the old rights in the old contract are not extinguished, then it is not novation. The extinction and right is necessary. Extinction of rights is necessary for the purpose of novation of agreement. The novation only applies where there is no breach of previous contract. If parties enter into an agreement, and that is a contract, and there one of the parties commit breach of certain terms of the agreement, after breach of the terms, there can be no novation. Novation takes place only when there exists a valid contract. That valid contract is substituted, but if there is a breach of contract, that is not valid one. This point has been stated in PLD 1961, Karachi 599. Section 62 applies only when there is breach of original contract. When there is no breach of original contract, meaning thereby that if there is breach of the original contract, then there can be no novation. The novation can take place only when no breach of the previous one is complained of. So the basic thing which this authority enumerates is that there should be a valid contract in existence at the time of substitution, and any breach which makes the contract unenforceable cannot be novated. Meaning thereby that mutual consent is necessary. There should be no breach in the previous one, and the party should be mutually willing and ready to substitute the same, so the mutual consent is necessary. Meaning thereby that it is not a one-sided affair. Only one party cannot enter into novation. One party cannot alter the same. There can be no substitution by one party. There should be both parties who are agreeing to the novation of the agreement. This point is elaborated by 2000 CLC, page 819, where only one of the persons to the contract alleges novation or alteration in the original contract, but fails to establish the same, the parties to the contract are not absolved of the liability of obligation in the original contract. Substitution or novation of a contract takes place only by mutual consent of the parties. If one party says that it has substituted the agreement, it cannot avoid the consequences of the original contract. The terms and conditions imposed in the original contract must be followed by both the parties till both agree to the substitution. So it is not a one-sided affair. There should be mutual desire and consent and willingness to substitute the contract. If there is a breach of original contract, then there will be no substitution. This point is established in those Achar SCMR, page 1084. Where a party had committed a breach with regard to the original contract provisions of Section 62 of Contract Act 1972 were not applicable, meaning thereby that the provision of Section 62 will apply only when no party has committed any breach of any condition of the original one. The simple is the matter that whenever any breach of the original contract is established, there can be no novation of the agreement. Now the question is, there is a contract, there is novation, then what is its effect? The section itself says that the original contract need not be performed. Original contract shall not be performed when there is novation. On the question of novation, when there is a novation, when there is a valid contract, original one, and that is replaced by a substituted agreement having the force of law and may be enforced in the eye of law, and there is a valid agreement, that may be substitution. But the effect of it will be that the first agreement shall stand extinguished and need not be performed. No one of the parties can claim any right under the first one. No party can seek the enforcement of the first one. No party can establish the terms and conditions of the first one. It is very simple that when there is novation, the original contract need not be performed. 1994 CLC, page 272. Give the effect of novation. Substitution of a new obligation. It is 1994 CLC, page 2272. Substitution of new obligation for an old one would render rights of parties under the original contract as completely extinguished, giving way to different rights in the subsequent agreement. So when the subsequent agreement shall be enforced and the first one need not be performed. In other words, that cannot be performed. The same effect has been elaborated in 1991 MLD 333. Parties to a contract agreeing to substitute a new contract for the original one and rescinding or altering the same, original contract need not be performed. Any unilateral act of a party favoring the other party, like unilateral increase in rent by tenant and its acceptance by the landlord, would not be novation of original contract. So meaning thereby that the original contract, when there is novation, that shall not be performed. But if there is no novation, then the original shall be acted upon. What is the effect of novation? Once a party, C2018 SCMR 1586. Once a party novated a contract, then enforcement of the earlier agreement could not be sought in terms of Section 62 of the Contract Act 1972, unless it was expressly stipulated in the fresh agreement that his rights in the original agreement would not be prejudiced. So it is the effect of novation that enforcement of earlier agreement could not be sought under section 62. The effect is given in 2000 CLC 1502, where the parties to a contract agree to substitute a new contract for the old one or to rescind or alter the same, the original contract need not be performed. This is what is the intention of the section 62 is, that where there is novation, alteration, the contract which was originally entered into should not be performed. So, if we find that what the novation is, we find that there are two contracts. One is the original one and second is substituted one. The substitution takes place on the desire of the parties. So the basic ingredient of novation is that there should be desire of agreement by both the parties. And both the parties should agree to extinguish the liabilities, rights and duties of the original one and replace it with a new one. When a new one is replaced, the original contract need not be performed. So this is what section 62 says.